Good afternoon, everyone, and welcome to a webinar titled Design Assist and Delegated Design, Exploring Collaborative Concepts. My name is Mike Koger. I'm an attorney with the American Institute of Architects Contract Documents Department. I've been working with AIA contract documents for about 10 years at this point. I started off my career as an architect, and also before working with AIA contract documents, I worked in private practice doing litigation, representing contractors, developers, architects. So that's a little bit about myself. In this presentation, I'm going to be talking in depth about design assist and delegated design. I'll be pointing out some of the key differences between these two collaborative techniques and pointing out areas of risk for architects and contractors. These are practices that have increased significantly over the last 5 to 10 years, and we've been doing quite a bit of work and research in recent years with the AIA Contract Documents program in order to better understand these practices and account for them in contracts. What we have found in our research is that there is a pretty good common understanding in the industry about what delegated design and design assist mean. However, there are some outliers where what I kind of like to say is that if you were to go and look at websites that talk about delegated design and design assist, you'll find out of 8 or 9 articles or websites that talk about these topics, 8 or 9 of them will agree with each other, and then you'll find 1 or 2 articles that say something that's a little bit different. So we believe there's a common understanding in the industry, but just be aware that there is information out there that kind of runs counter to the majority position. So before I get too much further into this presentation, I should do a few housekeeping items. First of all, this presentation is protected by US and international copyright laws. Please don't copy it without the permission of AIA contract documents. Also, this is not intended to be legal advice. I will be talking about the laws of some jurisdictions, of some states throughout this presentation. I'm also going to be showing you some case law examples to show you how courts have interpreted delegated design and design assist issues. Just keep in mind that while a lot of the issues that we're going to talk about in this program there are some commonalities amongst the states. State law is state specific. So if you have an issue on a project involving delegated design or design assist, don't trust what I'm saying in this presentation. It might not apply in your jurisdiction. You need to talk to an attorney who is licensed in your state, who can take you through and working through the issues that you've got on your particular project, who can key you in on the laws of your particular state. Also, this program is registered with AIA for continuing education credits. This program has been approved for 1 learning unit and a health safety and welfare credit. So if you have signed up for this, if you're an architect, if you signed up for this program, you should be seeing that on your transcript within a few weeks. If you don't, please reach out to us and we'll make sure that you're able to get credit for this program. So I'm going to give you a little bit of background about the research and the work that we've done at AIA Contract Documents from a high level, and then I'm going to go into some pretty good detail about design assist and delegated design specifically. We kicked off our work on design assist and delegated design a few years back by teaming up with the American Institute of Steel Construction to write a white paper to help define these two practices. At that time, we interviewed a whole bunch of people in the design and construction industry about their practices, and we asked them what the terms delegated design and design assist mean to them. We also researched a significant amount of case law and how courts have interpreted these terms as well. And so keep in mind that when I talk throughout this presentation, a lot of times I'll say, well, we define delegated design and design assist like this. And just keep in mind that our definitions match what the consensus in the industry told us when we went out and did this research and created the paper that you see on the left side of the screen. And in creating this paper that you see on the left side of the screen here, we talked with folks from the AIA Contract Documents Committee. We talked with folks from the ABA Construction Forum group with American Bar Association. We also talked with contractors and subtrades. Our goal was to make sure that we were creating resources that accurately reflected the industry. Our goal was not to create something new or to be revolutionary in any way. What we were trying to do is to write a paper and write contracts around the consensus about what the industry was doing with regards to these particular collaborative techniques. So this culminated in 2021 with the AIA Contract Documents Program creating two agreements. One is the Design Assist Agreement, that's our C403. That is styled as a client and a consultant agreement for Design Assist services. Oftentimes that client's going to be the owner of the project. The consultant will be a sub-trade of some sort who is doing Design Assist services. We also created a Delegated Design Agreement, which is the C404, which is a contractor to consultant agreement. So if a contractor, like a sub-trade, is required via performance specifications to engage a design professional, to have a design professional actually stamp and sign drawings for the portion that they've been delegated, this is the agreement that you can use to hire that sub-trade. So this slide shows the big overview of design collaboration in construction contracts. Design Assist, Delegated Design, and Design Build are all confusingly similar sounding phrases. Our research has shown that there is a spectrum of design collaboration, starting with informal involvement, which is a casual conversation between a design professional and a contractor that has no real contractual underpinning and no expectation of reliance. The next step along that spectrum is Design Assist, where there is a contractual arrangement for design-related services, but no transfer of design responsibility. The next piece along the spectrum of design collaboration is Delegated Design, where there is a transfer of design responsibility for a portion of the project, but that design responsibility is transferred to a second design professional who is hired by the contractor or a sub-trade. Lastly, we have Design Build, which is, of course, a project delivery method where a design build entity takes on the entirety of the design responsibility of the project. And I think it's important to look at this big picture kind of comparison of these different collaborative techniques, because a lot of times folks will get them confused. Certainly, folks get delegated design and design build confused quite a bit. And I'm going to go through these all in a bit more detail, but I think it's important to see the entirety of this, because I'm not going to talk about design build in this program, but just know that it is often confused with delegated design. So that brings me to Design Assist, which I'm going to talk about in a pretty good amount of detail here over the next 10 or 15 minutes. And here's the definition that we settled on. Now, I won't read the entire thing, but I'm going to focus on a few of the key features of Design Assist. First, Design Assist is not informal. The contractor will have a contract describing the Design Assist services that it will provide, and the design professional who is receiving the assistance will have a contract describing to what degree they can rely on the assistance. Now, these contracts might not be with each other. In fact, they are almost never with each other. Oftentimes, they're going to have the architect and the contractor are going to have independent contracts with the project owner. That's, the typical scenario for a design bid build or a CM project, and that's how the Design Assist contracts are usually structured as well. Although we have seen, as I will show here in a few minutes, some different examples of how Design Assist services are structured. Second, the contractor and their subs are merely assisting the design professional. They are not taking on full control of any aspect of the design or preparing formal construction documents. The contractor isn't signing or sealing drawings or otherwise acting as the designer of record for any piece of the project. So what naturally flows from that is that the design professional maintains control over all aspects of the preparation of the construction documents, including the responsibility to integrate contractor-provided information into the design. And one thing that we learned when we were talking to folks in the industry about the way they do Design Assist is that it's often very common for folks to start doing Design Assist services during schematic design or design development, and then eventually take on delegated design responsibilities later in the project during the construction phase. So I mentioned earlier that we interviewed a number of contractors and subs about their experience providing Design Assist services. And the responses that you're seeing here are from those interviews. We've of course redacted the folks who actually, gave us these quotes or these these little snippets about their practice. As you can see, while CMs and trade contractors provide a wide range of design assist services, one thing that is pretty universal is the type of input these builders are providing on the design assist scenario. They are providing input based on their own expertise as builders. And this is one of the main differences that we identified between design assist and delegated design. So in a design assist scenario, the contractors and subs are providing input from their expertise as builders about things like installation, constructability, job site logistics, scheduling, these kinds of things, right? They are not duplicating the work of an architect or second guessing the architect or engineer in any way. However, in delegated design, the contractors are actually providing professional design services that kind of pick up where the primary design professional left off. And that work is often done through a second licensed design professional. Some things that are important to think through when it comes to doing design assist services is the contractors who are providing these services should really be thinking along the lines of getting professional liability insurance. Now, we've talked to plenty of professional liability insurance carriers about design assist, and what we found is contractors are not going to be able to get a policy that is similar to what an architect or an engineer would get. It's not a professional design policy, but it is something that would tend to be called like a miscellaneous professional services policy to cover potential errors and omissions from the work, from the design assist services that the construction manager or whoever is providing these services might provide. We've also found that design assist typically happens during schematic design or design development, and certainly from the folks that we interviewed along the way before putting together these agreements and the paper that I mentioned earlier, the consensus was that the earlier design assist input happens, during schematic design or during the design development phase, the more it is likely to be seen by the design team as actually being true collaboration. The later design assist input, during the CDs phase, when most of the major decisions have already been made, the design team is often going to see that as value engineering or second guessing, and it is certainly going to lose a lot of the potential benefit that design assist could have offered had it been done early on or earlier on in the design of the project. So the most common design assist services are those that are found in the pre-construction phase of projects done in a construction manager at-risk delivery method. That's why I keep saying construction manager, because that's what most people think of when they think of design assist services. And these are things like cost consulting, scheduling, establishing BIM protocols, or helping the architect establish BIM protocols, providing recommendations about equipment and materials, and constructability reviews. And if you want an example of what this looks like in an agreement, take a look at our AIA contract document A133. That's our owner construction manager agreement at section 3.1.1. So I'm showing the very first part of that provision, but if you want a real detailed look at what these design assist services look like, look at the remainder of that section. And of course, design assist services can be and are often done not just by the construction manager on a project, but also by its subs and its sub trades at a far more nuanced and specific level to whatever that sub trade is performing, whatever kind of work that they're eventually going to perform. I also want to focus on one specific provision of the A133 that I think gets to the heart of design assist services from a contractual perspective. And this one's really important. It's why I put it up here, even though it's a big block of text on a slide, which I like to mix in images as much as I can, but this text is really important. This section clarifies that the construction manager is not acting as a licensed design professional in providing these services, yet the CM does have a responsibility to, and I'm quoting here, exercise reasonable care in performing the pre-construction phase services. Also, the architect and the owner have the right to rely on information and services furnished by the construction manager. So from a regulatory perspective, it's important to know that the architect is going to be responsible for the design, but they will have very likely have valid defenses against errors and omissions claims by the owner if the CM or its subtrades provides inaccurate information or for services that they provide that fall below a reasonable care standard. So from contracts and payment for design assist services is where we found a great deal of divergence amongst folks that we talked to. You know, the nature and the timing of these services, we found pretty good consistency. But when it came to how contractors are paid, how much they're paid, and how their contracts are structured, you know, we talked to people across the industry that were doing different things, right? And the most common, of course, is the construction manager and their subs providing design assist services, like I just mentioned. That's a very common way the design assist is done. And it can be, you know, anything from as simple as doing constructability reviews to doing full mock-ups and assisting the design team in a more detailed way on very detailed components of a building. Significantly more rare than that is that owners will have direct contracts with key subs during the design. And even more rare than that, although we have found some folks who do this, is that occasionally you will find that architects will have direct contracts with contractors or subs during the design phases of a project. Now, that is something that we do not have documents that are structured in that manner, and it probably, you know, almost certainly would result in more risk for an architect, but we have certainly talked to people who have done design assist services in that manner. One thing that we have learned from interviewing folks in the field and in this industry is that compensation is critical. A lot of times you'll find construction managers and subs who will do design assist services as almost a loss leader in order to, and they will make up for the time that they're spent at the front end of a project by actually getting the work and building in a little bit more cost into their fee for the work. But when we've talked to architects, owners, and CMs too, they have pretty uniformly said that the design assist services are better if you actually pay them, the CMs and their trades, a real rate, you know, that is commensurate with the amount of work that they're doing at the beginning of the project during the design phase. Okay, so design assist offers many benefits. The design team has the opportunity to get input from a construction manager or a contractor before the design is fully developed. And this could result in a more efficient and a better design. Sometimes it does. Also, the construction manager and contractor have an opportunity to become familiar with the project well before they are expected to start construction. And this has a tendency to expedite the construction process and hopefully limit RFIs and change orders. I know that when I did architecture before, you know, embarking on a career as an attorney, I almost always was involved in construction manager at-risk projects where we knew the construction manager and we worked with them during the design. So we certainly noticed that there was efficiency, an efficiency when it came time to starting construction, that there weren't so many questions up front, there weren't as many change orders and RFIs. But I don't want to imply that design assist does not come without some serious problems in some cases. So when we talk to builders and design professionals about design assist, you know, we asked them, you know, what are some of the negatives that you've encountered when doing design assist services? And no surprise, there were, you know, several folks who told us that there were some negatives that they encountered. From a builder's perspective, they would note and have noted that owners often don't want to pay for design assist services. And builders are also very concerned that they are seen as buying into design problems when they participate in the design phase of the project. And whether they said it explicitly or not, the reality is that doing design assist services has the potential to weaken a contractor's spur and protection, which I will get into the spur and doctrine in the next slide. So I'll just put a little placeholder right there, and I'll describe that here in just a moment, what I mean by that. Design professionals also noted that when design assist went bad, it was when construction managers and contractors were perceived as not providing real value, right? Occasionally when they would be asked to do design assist services, they would do them later in the project and they would be seen as just participating to second guess the design and value engineer. Also, of course, anytime you add new parties in to review a design submission of at any level, you're going to add new layers of reviews and coordination that might not have, certainly wouldn't have been there if there had not been those reviews in the first place. So there's a little bit more administrative burden at reviewing submissions. You know, if the architect is handing things off to a CM for an early review, you're going to have a little bit more review and coordination up front. So I want to go back to the issue that I mentioned just a moment ago about contractors being concerned that providing design assist services in some way could be seen as them buying into design problems. And this is a real issue for contractors, and they're not at all wrong to be concerned about it. That brings me to two important cases that I'm going to talk about sort of briefly, but a little bit of depth here. These cases are separated by over 100 years. The first case is the United States versus Spurred, and it was decided all the way back in 1918. The Spurred case is the most important and far-reaching piece of American jurisprudence that touches on construction law. I'm going to talk about the Spurred case in a bit of detail because I think it's important for everyone to see how the law differentiates a design bid build project where there is no design collaboration of any kind from cases involving design assist and delegated design. So this case, I think, is a touch-off point for a few of the other cases and issues I'm going to talk about later. So United States versus Spurred, if you're not familiar with this case, which some folks are, some are not in the industry, it started, so this is a dispute back in 1918 about the Brooklyn Naval Yard, which was a huge shipbuilding yard that's located in Brooklyn. It was active between 1801 and 1966. It's located, if you're familiar with New York City, you'll know exactly where these red dots are. It's this red dashed outline of the Brooklyn Naval Yard. It's located between the Manhattan and Williamsburg bridges. It's the first ever federal shipbuilding yard, and some of the largest ships that have ever been in the Navy's fleet, a lot of which fought in World War II, were built in this shipping area. Uh-oh, I went forward too fast. Okay, sorry about that. So Spurred was a contractor who agreed to build a dry dock for $757,000. The US Navy was, of course, Spurred's client. They hired Spurred and provided him with plans and specifications for the dry dock. This was a traditional design bid build project, so Spurred had zero influence over the design drawings in any way. And that's very important, as you'll see with subsequent cases that involve design assist and delegated design. Spurred complied with the plans and specifications, which included relocating a large sewer pipe away from the dry dock that it was building. During a large rainstorm, when the work on the dry dock was still underway, the sewer backed up and broke, and this broken sewer line ultimately caused pretty expensive damage to the surrounding site. So I'm oversimplifying a very important case with these little figures, but I want to make this point as clearly as possible. The US Navy then sues Spurred, arguing that Spurred built a defective sewer. And the Navy's case, which it made in pretty good detail, can be summed up like this, right? The Navy said, you as the contractor, Spurred, were supposed to examine the site and make sure that it was suitable for the work and check the plans against the site conditions. Also, you were responsible for the entire project until I, the owner, the US Navy, accepted it as complete. Spurred made a much more simple argument. And again, I'm simplifying it here for an effect, but Spurred's argument was, you gave me defective plans and specifications. I built according to them and it still broke. It's not my fault. So no surprise here that Spurred wins this argument. And from this case, we get what is referred to as the Spurred Doctrine. And it goes something like this. I'm quoting here. If a contractor is bound to build according to plans and specifications prepared by the owner, the contractor will not be responsible for the consequences of defects in the plans and specifications. This is also known, you'll hear this called as the implied warranty of adequacy. And in other words, when an owner provides plans and specifications to a contractor, the owner warrants that the plans and specifications are adequate to construct the project. Okay, so why did I just go through a Spurred, a description of the Spurred case that's over 100 years old? The reality is that there are a long line of cases that evolved from the Spurred decision. I'm not going to go into all of that nuance, but it's important to note that the Spurred case assumes that the contractor had zero input into the design of the project. And it's true that the Spurred case was a design bid build project and that Spurred had no input, right? So the question then remains for projects involving more collaborative techniques like design assist and delegated design, what if Spurred was a construction manager and provided design assist services? Also, what if Spurred was actually delegated a portion of the design and had some discretion about how to design and ultimately build that sewer line that eventually broke, right? And there's a lot of cases that touch on these issues, one of which I think is very important to talk about in a design assist scenario, and that is the Coughlin Electrical Contractors versus Gilbane Building Company case. It's it addresses the question of whether a contractor can rely on the implied warranty of adequacy if the contractor had some degree of influence over the plans and specifications. This case is from 2015. It's out of Massachusetts. I want to highlight that the picture that I'm showing here is definitely not from this case. This is a picture of the interstitial space at the Salk Institute in that building in San Diego, California, or La Jolla, California. The Salk Institute is famous for having one of the first very deep interstitial spaces above a lab space, which allowed equipment to be kind of moved and changed out over time. The Coughlin case is something of the exact opposite of this. So the facts of this case are pretty straightforward. A state hospital hired Gilbane as a CM at risk to build a psychiatric facility in Massachusetts. Gilbane then hired Coughlin as an electrical contractor, electrical subcontractor, and somewhere along the way, Coughlin ran into problems installing the electrical system because the interstitial space between the ceiling and the bottom of the structural steel was designed at 2 feet, but according to Coughlin, it needed at least 5 feet in order to do its work. Now, that's a huge discrepancy of the amount of space in an interstitial space above a ceiling or between floors. And the case doesn't really go into how that happened. But Coughlin sued Gilbane under a spear and basis, arguing that it was building the electrical components out according to the plans, but the plans were inadequate. And they didn't provide enough interstitial space, and it cost Coughlin both time and money to work around the deficiencies in those plans. Coughlin then sues the owner under the same theory that the owner breached the implied warranty of adequacy with regards to the defective plans. So the court then takes up this question of whether or not an owner gives an implied warranty regarding the plans and specifications in a CM at risk project, recognizing that in a CM at risk project, the CM has an ability and an expectation to review the plans and do a constructability analysis. The conclusion that the court comes up with is that yes, the owner still does give an implied spear and warranty, but it is a more limited warranty than in a design bid build project. And here's what should be concerning to contractors providing design assist services. The reality in this court understood the nuances of design assist and construction management very well. You can see that from the quotes on the screen. I'll try not to read too many of these, but this is, it shows that the court understood the issues very well. And the takeaway from this case really is that the more design services you perform, the less you can rely on the spear and warranty, right? Now, this case was eventually remanded back to the trial court, and the outcome was probably highly dependent on whether or not Coughlin and Gilbane had an opportunity to notice that 2-foot plenum space during their constructability reviews. But it's an important case to read and to understand that if you are a contractor doing design assist services, you need to understand that when you're reviewing plans and specifications from an architect that's been handed to you by the owner, that you're going to need to look at them closely, because when you eventually bid on this, you might not be able to rely on a spear and warranty in the same way if you had a chance to notice and to actually inform the architect that you didn't have enough space, for example, to work in an interstitial space like in the case of Coughlin. So that leaves me to tips for a design assist agreement. First, and importantly, negotiate and execute a real agreement, not a letter of intent. There are a few cases out there. I'm not going to summarize them or describe them in a way that I did the other 2 cases a minute ago, but there are a few cases out there that I found where contractors, CMs, and subtrades have just entered into like a letter of intent kind of an agreement with an owner for design assist services, understanding that eventually when they get to work, they'll fill out a complete agreement. You get all kinds of questions that come up as far as what happens if the contract is terminated before construction work starts. What about the design work, or the design assist work, I should say, that the CM and their subs are actually doing, or can the owner continue to use that in a termination scenario? A lot of times letters of intent don't handle or don't address these issues. They don't address things like insurance. So it's important to negotiate and execute a real agreement. This is a shameless plug for the C403 design assist agreement that I mentioned earlier on in this program. It addresses all of those kinds of issues that a letter of intent might not otherwise cover. Also, be very clear about the roles and responsibilities of each party. And if you're creating a design assist agreement, make sure that you're detailing, what pieces of scope are in the CM or their sub-trade in their realm. What things are they supposed to be? If they're doing a review of the design drawings, what are they going to be reviewing for? Is it constructability? Is it logistics? Installation? Like what items are they actually are going to be reviewing the drawings for? Also, of course, require the CM and their subs to provide professional liability insurance as well. And then also be very clear about what happens to the CM or subs work product in the case of a termination, or if they do not get the contract to perform the work. Again, like I said, there's been a few cases out there where folks have had to go literally to court to get answers to these questions because they did not have agreement that addressed them. So next, I am going to shift gears and talk about delegated design. We define it, and when I say we, I basically mean the white paper that the American Institute of Architects and American Institute of Steel Construction constructors created a few years ago, but it is basically where we went out to the industry and talked with folks in the industry and got their definition. So I say it's our definition, but really this is a consensus industry definition. We define delegated design as when a contractor assumes responsibility for an element or a portion of the design. And that phrase, element or portion, is a key phrase. We're not talking about delegating the entirety of the design, we're talking about just delegating a piece of it, typically something that is fairly complex and can be better and more efficiently performed by a design professional who specializes in that particular system. You will see delegated design in mechanical systems, fire protection, retaining walls, lab spaces. The reality of delegated design is that it's been around for a very long time. You do not typically have your architect or your structural engineer doing truss calculations on a project, and you never really have, right? Those are always done by the truss manufacturers and the design professionals that they hire. What we've seen, of course, in the last 10, I guess, or 15 to 20 years is that more complex parts of a project are being done in a delegated design manner. So whereas 20, 30 years ago, perhaps it's just things like truss calculations, retaining walls. Nowadays, it's curtain walls, panelized exterior wall systems. It is more complex parts of a project that are being done in a delegated design manner. So delegated design itself can be a very confusing term. The reality of delegated design is that there is some level of split design responsibility going on, contrary to what that term might somewhat seem to mean. Here's how the responsibilities in a delegated design scenario break down. Starts with, of course, the primary design professional signing and sealing the construction documents. Those construction documents will often have performance specifications that establish design criteria for elements of the design that are to be delegated. Next, it is up to the contractor and their delegated designer to achieve the design criteria established by the construction documents, and then, as usual, sign and seal the drawings and specifications for that portion of the work. Next, the design responsibility kind of goes back over to the primary design professional to review the delegated designer's submittals for conformance with the design concept expressed in the original design criteria, and then to also, and importantly, coordinate the delegated design with related work. And this is something that is an important responsibility of the primary design professional to make sure that whatever piece of the project they have delegated out, if it's a curtain wall system or a panelized wall system, it's the architect and the structural engineer's responsibility to coordinate that portion of the work with adjacent work that needs to tie into it. Oftentimes when you see disputes about delegated design, it's that kind of coordinated coordinated with other materials or other portions of the building is where things break down and when you have issues. And then lastly, of course, once the design work is completed, it's up to the contractor or their sub to perform the work once it has been designed. So here, I just want to show that the A201, general conditions for the contracted construction, that we all know it has a process for delegated design already built into it. And no surprise, the definition that I stated earlier, it matches up with the A201 pretty well. I'm paraphrasing here, but the A201 sets up a process where the primary design professional can delegate portions of the design through the contract documents that it prepares. Notably, the A201 does not use the phrase delegated design. And it is somewhat buried. This language is somewhat buried in section 3.12.10.1, right in the middle of Article 3, the contractor's requirements. However, I should note that this language has been pretty uniformly identified by practitioners, by experts, even by courts, of course, as being delegated design in nature. There was a case in the 1990s out of New York that quoted this language extensively and referred to it as describing delegated design. A201 also captures the idea that when a contractor assumes delegated design responsibilities, it is often going to hire a secondary design professional to provide those services. And that secondary design professional will be responsible for signing and sealing their own drawings and specifications. And if you want enough, for years, we had contractors call us up and ask us, whether or not we had an agreement that you could actually use to fulfill this obligation. And sure enough, eventually we created this agreement. It's, as I mentioned earlier in the program, it is our C404-2021 contractor to consultant agreement. So when a contractor needs to hire a consultant, a design professional for these services, that's the agreement to go to. And there's also an important two-way reliance dynamic that exists in a delegated design scenario. This is also found in the A201. This paragraph, it's been now on 3 different slides. It has a lot of important information if you're doing delegated design. I think as an architect or a contractor, you need to know it inside and out. The contractor is entitled to rely on the adequacy and accuracy of the performance and design criteria, while the owner and the architect are also entitled to rely on the adequacy and accuracy of the services, certifications, and approvals performed by the contractor's design professionals. So just as with Design Assist, there are, there's some good things that come with Design Assist, of course, right? The efficiency of being able to rely on secondary design professionals who are experts in whatever proprietary system that is being spec'd out, like a curtain wall system. There's real efficiency in that. But there's also no shortage of potential problems that can arise in delegated design. So I'm going to go through some of those right now. Builders will often say that they feel like they are caught in the middle of 2 design professionals. And there's also this instance, as I described earlier, you've got really, while it's called delegated design, there is real split design responsibility going on. And if there is a problem with a component of the building that has been delegated, the chances are both the architect and the contractor who perform the delegated design services are going to be sued. And the reason for that is that owners really don't know. I mean, imagine yourself as an owner in a situation where your curtain wall leaks and you don't know whose responsibility it is. So now you might be, as an architect, able to get out on summary judgment, or might be able to get out of litigation early if you can show that you delegated design entirely down, and that's the piece of the project that had a defect or an error. But chances are initially you're both going to get brought into the lawsuit. Also, there are more sphere-in issues. Contractors are, again, potentially seen as buying into design problems that may arise. I'll go into that in more detail in just a moment. And then, of course, from a design professional's perspective, when we have talked to folks who have had bad outcomes or at least negative outcomes when it comes to delegated design, they've identified that some owners are pretty hesitant to allow delegated design. The feeling there is that, as an owner, you've hired an architect and a structural engineer to do the design work, and you don't want to, some owners will not want to actually allow portions of the design to be handed off to another design professional that they have not vetted. And then, of course, there's some things that you just can't delegate. And structural engineering is one of those things that is heavily regulated for good reason that I'll get into in just a moment. But there are some pieces of the project that you cannot delegate. Or well, certainly there's areas of responsibility that you cannot delegate as a design professional. So that leads me to the case of the Hyatt Regency walkway collapse in Kansas City. This incident happened in 1981 and has been the subject of a great deal of analysis and discussion ever since. Most of you on this call, if you're architects, as I assume most of you are probably very aware of this incident and know that it involves a wide range of failures on behalf of the structural engineer of record. This incident touches heavily on issues of delegated design and design assist, but it goes far beyond that. I want to underscore that before I start talking about how this incident is a delegated design issue. I want to say that there are many other failures that led to this disaster beyond just delegated design issues. One of those being, of course, that there was a senior structural engineer who relied on the work of a junior structural engineer who was grossly negligent in their work. So I'm not going to go into all of the nuance of this case, but I do want to preface that yes, this case, this collapse was partially caused by a failure of delegated design, but also it was many other things contributed to it as well. So if you are not familiar with this incident, the Hyatt Regency in Kansas City was a 45-story hotel building that was opened in 1980. I don't believe it's a Hyatt Regency anymore. I think it's a Hilton the last I checked. Don't quote me on that, but I don't think it's a Hyatt Regency anymore. This building had a pretty unique atrium. It was open, I think, 5 floors. It was like a 5-floor atrium at the very base of the lobby of the building, and it was open with walkways connecting floors on both sides. I'll show you some pictures here in a moment. The 4th floor walkway was positioned directly above the 2nd floor walkway, and both of those walkways were supported by the roof by hanging steel rods. Notably, there was a 3rd floor walkway that was off center. It was not aligned with the 2nd and 4th floor walkways that did collapse, and the 3rd floor walkway did not collapse. On July 17th, 1981, the 4th floor walkway gave way, causing it and a 2nd floor walkway to collapse on the lobby floor below. And 114 people actually died as a result of this incident. So here's a picture of what, not a very good picture to be honest, but it shows what this atrium looked like. You can see the arrows are pointing to the 2nd and the 4th floor walkways. The atrium level below was actually, what was going on at the time was a themed dance party that was attended by hundreds of people. Importantly, this is not a case of like overloading these walkways. When I originally heard of this case, I thought, oh, surely it must have been like hundreds of people on these walkways at a time. And that's not the case. Most of the people that died and most of the people that were even in this atrium space were on the ground floor at a dance party. And the 2nd floor had people on it. 2nd floor walkway had people on it, but not a tremendous amount. The 4th floor walkway had just a handful of people on it at the time. This is a picture, of course, of the aftermath of those 2 walkways falling down. Obviously, a considerable amount of construction debris fell on the folks below. And again, 114 people died in this incident. So in less than a week after the collapse, press around the country began reporting on a design change to the hanger rods supporting the walkways. The structural engineer's original design called for 6 continuous steel rods connecting to both the 2nd and the 4th floor walkways. During construction, the steel fabricator proposed that a single rod be changed to a double rod assembly that you see in the middle picture. The fabricator submitted shop drawings of the connection to the structural engineer, who approved them without reviewing the 4th floor box beam connection. And of course, the change effectively doubled the load on the nut and washer that are supporting the 4th floor walkway. So for the purposes of this discussion, it's important to note that the structural engineers made the argument that reliance upon fabricators to design certain structural steel components was the custom and practice within the profession. And here's a quote from this case. The thrust of the structural engineer's defense was that it was expected by them, in keeping with custom and practice, that the fabricator would design the connections, and they are not and should not be held responsible for the fabricator's failures. Now, another point of clarification here is that this is not an issue of one structural engineer delegating design to another structural engineers. the fabricators were not structural engineers, although they had experience with steel fabrication. They were not structural engineers themselves. So the court stressed in their decision professional accountability by a specific individual certified engineer. The court stated, and this is still, good law for, I assume, every state in the United States. Don't quote me on that, but structural engineer has a non-delegable duty of responsibility for the entire engineering of the project to which he affixes his seal. So again, this is a piece of responsibility that cannot be delegated down to anyone else. A structural engineer also cannot delegate connection design to a non-licensed structural fabricator, and a structural engineer will not be relieved of its professional responsibility by customary practice or by contracts. And the last case that I want to talk about, which again talks about delegated design in regards to the Spurred Doctrine that I mentioned earlier in this program, it's Frucon Construction versus the United States. And in this case, a demolitions contractor sued the government, basically making a Spurred claim, effectively arguing that the government provided plans and specifications that were inadequate for the work that a contractor was doing. And this case, I think, while some of the logic in this case is very, and I'll get into that in just a moment, it's very kind of intuitive, it brings about an important point about the role of performance specifications in delegated design. And there's some good language in this case, if you hang on for the back end of it, that I think an architect can really learn something about the importance of making performance specifications that actually delegate design rather than being part performance specifications and part prescriptive specifications or design specifications. So just to give you a little bit of understanding about this case, from a factual perspective, Frucon was the name of a contractor in this case and was responsible for demolishing a certain amount of concrete on a federal project. Frucon's blasting work, demolitions blasting work, ended up going too far, right? They overblasted and they damaged adjacent areas of work that were intended to be left alone. Frucon then sued the federal government for additional costs incurred to fix the areas of the project that were damaged. And the central issue in this case was whether the federal government had actually delegated design of the blasting protocols down to Frucon. And you'll, not surprisingly, I suppose, when you look at cases about delegated design, one of the common issues is that there's always a question, or oftentimes there is a question about whether or not a specification was a performance specification or not. And in this case, it wasn't entirely clear from the contract language whether or not the spec was performance or it was prescriptive or a design specification. So that led to a disagreement as to whether the government's blasting specification was prescriptive or performance. And the very notable problem with Frucon's argument was that it was pretty clear from the specification that it was, while it might not have said it was a performance specification, it was certainly performance in nature. And the key facts here were that Frucon was actually charged with designing most of the details about how to carry out the blasting requirements. It's kind of hard to say that you did not have a performance specification as a contractor when you actually had to design most of the details, right? So from this case, we get a pretty common sense rule that if you design to a performance specification and the performance specification itself is not in error, then you don't get to later come back and make a Spurred argument that the plans and specifications were inadequate. That seems perfectly fair to me. So and pretty logical as well. So from this case, we also get a nice discussion about the difference between design specifications. I sometimes call them prescriptive specifications. I don't know what, I'm not sure if there's a prevalent term in the industry, but the difference between design specifications and performance specifications. And the upshot is that it doesn't really matter what you call the specification, it doesn't matter what you label it. The court is going to look to the degree to which a contractor had discretion to accomplish the specification in order to make that determination. So in other words, courts are going to look beyond the mere title of your specification to determine whether a specification is performance or prescriptive in nature. And in the Frucon case, the contractor had a really good amount of discretion to design their demolitions protocol. So it was determined to be a performance specification. And if you want a nice example of a performance specification, I think this is a pretty good one. This one's actually a case that just comes a few years ago, Delaware State versus Thomas Company. If you look at the specification, this is for, I believe, very large exterior wall panels. And you look at part 1, construct a panel system to provide for expansion and contraction of component materials without causing buckling, failure of joints, undue stress on fasteners, other detrimental effects to the panel system or adjacent buildings, systems, or warping of the faces of the panel systems. What you don't see here are tolerances. The architect is not actually calling out, there needs to be a ½ inch gap between these panels, or the panels need to be made of this particular material in order to stop buckling or stop deflection or something. So that, to me, very clear that it's a performance specification. Same thing with another part of the same specification in that same case is the second half of this slide. It says fasteners or clips, anchoring devices, fasteners, and accessories for the installation of the panel system as recommended by the panel manufacturer for the system specified. Again, not calling out specific clips or anchoring devices, deferring to the panel manufacturer themselves. So if you are going to delegate design through a performance specification, actually delegate design. If you start putting in more detail that is prescriptive in nature, far more likely that you are not going to be able to shed that liability if there is something that ever goes wrong with a portion of the project that has been delegated. So at this point, we have a few minutes left. I'm going to flash on the screen some resources that we have. We have a Learn page that we have all kinds of articles and videos that we've done. You can also call us if you have questions about contracts or if you have tech support questions. But I am going to take some questions if anyone has any over the next 10 or so minutes. Molly, are you on the line? Have you got any questions yet?
I am. So we'll give some people some time to put some questions in if you have something that's come to mind. But while you were doing your presentation, we had a few come through that I think would be great for the group to hear that you can touch on. The first is going to be, please discuss what design parameters are necessary for delegated design. Many times we see delegated design with no associated load or deflection requirements, which leads to many RFIs.
Yeah, no, that's a good case, or that's a good question. And I think that, in fact, the last slide that I just showed has, a lot of times your performance specifications, it's kind of this game of like, how much do you want to include in them? But in that same specification that I just quoted, they did have loading requirements, and it's basically like a code required deflections is what I could tell. I'm not a structural engineer, so I don't really know, but I mean, at least what I was able to see in performance specifications that I've looked at, putting code required or code maximums for deflection, that seems to be an appropriate way to an item to include in a performance specification. That doesn't actually say how you achieve those deflections, but it at least shows what the outer limits that the code will allow.
And we had this sounds like it could be a follow-up to what you were just talking to, and you might not be able to give too much on this because it might border legal advice, but it said, since basic detailing will require references to certain sizes, is it acceptable to say like a minimum of 1/2 thick unless otherwise required by delegated design?
Well, good question. And I think honestly, I would probably need to know a little bit more about the context of that.
Yeah.
Are we still talking about wall panel systems or not? I'm not really sure, right? But at least, from an attorney's perspective, the last slide that I showed, and I'll just go back to it. Let's put it this way: if I'm representing the architect, like this is the kind of detail that I want to see. It's actually passing down responsibility to a panel manufacturer, and it is requiring them to come up with the design solutions for fasteners, clips, rather than the architect coming in and putting in, overwriting what perhaps the panel manufacturer might require. I'm not sure if that actually answers the question, but just from a risk mitigation perspective, this amount of detail is far better from an architect's perspective.
So then going off in a different direction, someone said, I think I heard at the beginning of the presentation that in design assist, the contractor or specialty contractor is not technically providing design services. They are instead providing feedback on logistics, constructability, materials, scheduling, etc. Can you confirm?
Right, they're not certainly not performing professional design services that an architect or a structural engineer would provide. However, they are providing advice on some level, and that's where, you know, when I say you should really be thinking along the lines of having professional liability insurance. It's to cover that kind of advice that could end up being bad advice, right? But yeah, right. In a design assist scenario, you're not doing professional design services that will require the skill and training of an architect or the stamp or seal of an architect. It's very different than delegated design, where you are actually expected to do professional design services.
Awesome. So this one, again, you can always tell me if we're teetering on that legal advice. So can you require a delegated designer or general contractor to verify existing construction that may affect the new design in accordance with the design documents and report any variances to the AE prior to shop drawing submission?
Yeah, no, that's a good question. And it's so case specific. Like, you know, I mean, can you require them? I mean, you probably could, right? I guess that's very like case and instance specific, that I kind of don't want to wade into it without knowing more, right?
Yes. This one might be a good one. So I had the same question as you were talking. As an owner with multiple ongoing new project requests, how do you recommend a design assist annual contract to be structured, which covers multiple projects?
Oh, interesting. So so I guess we're talking about an owner who's hiring a contractor kind of at an ongoing basis to provide uh, some degree of like constructability analysis over multiple projects. It somewhat depends on, like, you know, is this contractor that they're hiring going to actually be doing the work? I mean, it almost sounds like in that question, they are not going to be doing the work. They're just going to be providing advice, like a CM as advisor. We do have like I said, our C403 design assist agreement is structured. I mean, certainly you can amend that over time. It is not structured as a master agreement. Like, what you really want is like a master agreement with like work orders or service orders attached to it. That particular document is not structured like that, but you can use it as a master agreement if you just continue to amend it over time. I'm not sure if that's particularly helpful, but I mean, it does kind of depend on whether or not the contractor or the CM that's going to be providing design assist is like actually intending to get the work, because oftentimes you'll have contracts that are bundled, like a construction manager, you know, it has pre-construction phase services and then it's got the work attached to it as well. That's kind of together. But yeah, I think the C403 and just amending that would be my best, you know, recommendation for that.
Well, I think this will be our last question based on time, but while you're talking about agreements, is there a way, this one says to recommend language to incorporate a design assist process into an owner architect agreement, or do you have a path that should take?
Interesting. So certainly our B133 is an owner architect agreement for a construction manager project. And that is going to have services built into it for, like, effectively to have the architect communicate and work with the construction manager and their subs during the design assist phase. So the B133 is the document that I would look at for how to integrate that into it. Of course, that's assuming a construction manager as advisor project delivery. So if you're not I mean, a lot of times design assist is a construction manager at-risk project delivery method, and if you're doing that, then the B133 is perfectly suited for it. If you are not, if you are doing some other kind of design assist that is not assuming a construction manager, then I think the B133 is a decent guide, but it might not work perfectly for you.
So with that, I think there are so many amazing questions that came through. Mike, if you want to jump back to the screen with the resources, I know we can't keep Mike here forever, but if we didn't get to your question, feel free to send them along to that docinfo@aiacontracts.org. They can try to answer your question. They might even pass you along back to Mike, but unfortunately, I can't keep him forever.
Yeah, just shoot us an email and we'll try and write you responses.
Yeah. So thank you so much for your time. Thank you, Mike, for this amazing presentation. And we hope you have a great rest of your day.